day, I'm Neoh with the metric number 270340. Here today, I would like to share with you the striking out pleadings in Malaysia. First of all, in striking out a pleading, a party may apply to strike out either the opponent's pleading or any part of it. The principles upon which the court acts in exercising its power to strike out the pleading is it must only in plain and obvious cases that recourse should be had to the summary process under this rule, and this summary procedure can only be adopted when it can be clearly seen that a claim or answer is on the face of it's obviously unsustainable. Hence, it is notable that using the summary process under this rule is only permissible if and when it is obvious that a claim or answer is obviously unsustainable on its face. Next, moving on to the questions of who can apply to strike out the pleadings. The answer to this question is both parties to the proceedings. Either the plaintiff or respondent is able to file a notice of application supported by an affidavit to strike out the pleadings. If the plaintiff is applying for striking out, there is only one application, whereby it is to apply to strike out the defendant's defense, either whole or part of it. If the plaintiff applied to strike out the whole of the defense, the court will give the judgment to the plaintiff. In contrast, if the plaintiff chooses to strike out the part of the defense, the court must ask the question, is the remainder of the defense enough to sustain as a defense to the plaintiff claim? If yes, the remainder is enough, the court will proceed the case. If not, the court will grant the judgment to the plaintiff. Next, if it is the defendant who is applying for striking out, two possible applications could be made. Firstly, defendant may apply to strike out the plaintiff's statement of claim, either whole or part of it, in which plaintiff actions will be dismissed. If defendant applies to strike out part of the statement of claim, the court will ask the same question as to whether the remainder of the statement of claim is sufficient to bring a cause of actions against the defendant. In such a case, if the plaintiff's statement of claim is sufficient, then the plaintiff actions will proceed. If the plaintiff's statement of claim is insufficient, then the plaintiff claim will be dismissed. Secondly, defendant may apply to strike out the plaintiff endorsement on the writ. In this context, plaintiff actions will be dismissed with cause. Once the endorsement is struck out, there is no more cause of actions. Followed by this, I will further explain on the procedures of striking out the pleadings. The procedures of striking out the pleadings is governed by Order 18, Rule 19 of the Rules of Courts 2012, hereinafter referred to as the ROC 2012. It is notable that the applications of striking out the pleadings needs to be made by way of notice of application supported by an affidavit. The affidavit in support must state precisely which ground the applicant is relying on to strike out under Order 18, Rule 19, Sub-Rule 1 of the ROC 2012. This can be seen in the case of Rashha Enterprise and Jiran Berhad versus Arab Malaysian Finance, whereby the court held that the plaintiff application was invalid and flawed because it did not state which link of Order 18, Rule 19 of the ROC 2012 it was made under. Moreover, the application must be stated promptly and precisely describe the type and nature of the order being sought. For instance, in the case of Jamil bin Hassan versus Kang Min, the court ruled that the application should be made promptly, usually before the close of the pleadings, and that it may be denied or refused if the case has already been scheduled for trial. Lastly, it is important to note that an application to strike out must be made without any delay. Speaking of the grounds on which the pleadings which can be struck out, we can refer to Order 18, Rule 19, Sub-Rule 1 of the ROC 2012. Pursuant to Order 18, Rule 19, Sub-Rule 1 of the ROC 2012, parties may, at any stage of the proceeding, make an application to the court to strike out pleadings on grounds that the pleadings, firstly, disclose no reasonable cause of action or defense, as the case may be. Secondly, is scandalous, frivolous, or vexatious. Thirdly, may prejudice, embarrass, or delay the fair trial of the actions. Or lastly, is otherwise an abuse of the process of the court. The court may then order the actions to be stayed or dismissed or judgment to be entered accordingly. I will now explain the grounds one by one thoroughly. As mentioned before, the first ground on which the pleadings can be struck out is if there is no reasonable cause of actions or defense. Under this circumstance, the party can make an application to strike out the pleading if there is no reasonable cause of action or defense on the facts of the pleadings. I too should like to add that reasonable cause of action refers to a cause of actions with some chances of success when only the allegations in the statement of claim are considered. A pleading or part thereof will be struck out if the court is satisfied that even if all the allegations of fact set out in the pleading are proved, those facts which not establish the essential ingredients of a cause of actions or constitute a defense. For instance, in the case of Evans versus London Hospital Medical College, the court allowed the applications to strike out the pleading of the plaintiff. In this case, the plaintiff was charged with murder based on the post-mortem report provided by defendant's hospital on plaintiff baby, which revealed the presence of morphine in his organs. However, at the trial, the plaintiff expert's witness found that there was no morphine in the baby's stomach, and this point was not disputed by the prosecution and subsequently leads to the baby parents being acquitted of the charge. The plaintiff sued the pathologist for negligence. In response to the lawsuit, the pathologist applied for striking out on the ground that he gave the evidence in court. He was protected by privilege. The court agreed that there was no cause of action as whatever the pathologist did. He did it to assist the court and is protected by privilege. Therefore, the pleading of the plaintiff is struck out by the court. Besides, the court in the case of Taib bin Awang versus Muhammad bin Abdullah also held that an actions of malicious prosecutions was struck off because the trial was still in the appeal stage. According to the court, there is no cause of action since there is no decisions given by the court yet. Next, an application to strike out the pleading can be made if the pleading is scandalous, frivolous, or vexatious. Scandalous refers to matters that improperly cast a derogatory light on someone's moral character or language, and, in most cases, involve a party to the actions. An instance of frivolous or vexatious actions or statement is groundless actions and has no prospects of succeeding. The pleading is considered to be annoying, and it is often raised to embarrass or annoy the other party to the actions. For example, the pleading is considered to be scandalous, frivolous, or vexatious and can be struck off if the wrong party is sued, the defense is only a bare denial, or a limitation has set in. A pleading can be struck out due to the pleading is scandalous can be seen in the case of Pertamina versus Kartika Ratna Tahir and others. In this case, there was Mr. Tahir, who was a high-ranking officer in Pertamina, an Indonesian oil company. When Mr. Tahir died, he had a large amount of money deposited in a Singapore bank. The plaintiff claims that the money is in the bank and was obtained through bribery and corruptions, and that he had put these illegal gains in the bank in the joint account of himself and the first defendant, who is his wife. Subsequently, the plaintiff claimed the money. In response to this, the first defendant, who is the wife of the Mr. Tahir, alleged that not only the officers and her corrupt within Pertamina, but the corruption permitted across the company. Naturally, plaintiff applied to strike out the pleadings on the grounds that the pleading was scandalous and aims to embarrass. The court allowed the plaintiff applications and strike out the statement of claim of Mr. Tahir's wife. Besides, in the case of Malayan Banking Berhad versus Tan Kong Yam, it was held that the plaintiff succeeded in striking out certain paragraph of the defense on the ground that it discloses no reasonable defense or as being frivolous or vexatious. A pleading or part thereof may tend to prejudice, embarrass, or delay the fair trial of the proceedings if it contains allegations which are vague or imprecise, such that the other party cannot plead to such allegations specifically, or if it contains allegations that are irrelevant, unnecessary, or scandalous. This may lead to the striking out of the pleadings. For instance, The pleading is prejudiced and embarrassing if the defendant does not specify how much of the plaintiff claims is denied or the defendant raises issues that are irrelevant to the plaintiff claim. This is illustrated by the case of Lee Kuan Yew versus Chin Wei Kian and another, in which the defendant published 2 articles in the Sunday Star in Malaysia commenting on the suicide of Mr. Ted Chin Wan, Singapore's then Minister of National Development, and the failure of the National Bank of Brunei. These articles in particular commented on the effects of these incidents on the reputations of Singapore. The court held that the defendant's disclosures of general and obvious facts would embarrass the plaintiff, and therefore, the court struck out the defense of defendant based on Article 10 of the Federal Constitution. Last but not least, the application to strike out the pleadings can be made if there is an abuse of the process of the court. Abuse of the process of courts occurs when legal proceedings are used for improper ends rather than the actual purpose of achieving justice. In the case of Gabriel Peter and partners suing as a firm versus Wee Chong Jin and others, the court held that the term abuse of process of the court under this rule had been given a wide interpretation by the courts. It included considerations of public policy and interest of justice. The categories of conduct rendering a claim frivolous, vexatious, or an abuse of process are not closed and could depend on the relevant circumstances of the case. For example, in the case of Remington versus Scholes, defendant delivered his statement of defense by denying everything in the plaintiff's statement of claim, but making no case of his own. He failed to provide his ground of defense. The court was convinced that a pleading was a lie or a sham, and therefore struck out the statement of defense. In such a case, it is notable that the action cannot be commenced with an ulterior motive other than a genuine or real purpose. Moving on, there's a question to ponder. When the application for striking out the pleading can be made? Although Order 18, Rule 19 of the ROC 2012 states that striking out pleadings can be made at any stage, the application must be made after service. Because if it is not made after service, then there is no chance for the defendant to apply to strike out. In the case of Ong Lian Sim and another versus Teo Ka Hin and others, there is a delay or merely a year before the plaintiff applied to strike out the defense. The court held that it was not fatal, as the application may be made even after the close of pleadings. The court further established that there is no standard time limit to apply for striking out. However, the court narrowed down the time period of at any stage of proceedings in the case of Bank Bumiputra Malaysia Berhad and another versus Lauren M. Osmans, whereby it held that the application must be made before the close of pleadings, which is 14 days after defense is filed or before the case is set down for trial. After this period, any application for striking out should not be entertained by the court. In conclusion, an application to strike out pleadings is generally only granted with cautions and strictness when it is crystal clear that the course of actions or defense is unsustainable. This is because an order for striking out would effectively bring the proceedings to an end and prevent the party from relying on those pleadings in the future. That's all for my sharing. Thank you for making time to sit through this presentation.